So what if I die without an estate plan? Hi, I'm Dan Covington. I'm an estate planning attorney in Lawrence, Kansas. For 21 years, I've been helping people get their affairs in order so they can leave the legacy they intend. So what happens if you die without an estate plan? And this is to say, what happens if you leave assets in your individual name so they're not in a trust and you haven't signed a will? Well, you're going to go through, your estate is going to go through something that's called intestate succession. And this is Kansas law, a set of statutes in Kansas that is going to dictate who then receives your assets, depending on what surviving family members you leave behind and relatives. And your assets, because you don't have a plan and because they're left in your individual name, will need to go through probate court unless your assets subject to probate are valued less than $40,000. So this is a conscious choice you can make, and I guess it's a kind of a choice you make by acting or not acting. But that's the reality of leaving your assets without any kind of estate plan if you leave it in your individual name. Maybe a little less known is what happens maybe later in life if you become incompetent and you haven't put in together any estate plan. Well, the troubling thing here is, so if you became in a situation where you need someone to care for you and you're not, you don't have capacity to handle your own business and affairs any longer, there's no one, even a spouse doesn't have a natural right to sign on your behalf, to withdraw funds that were held in your individual name, to do things like that, to act on your behalf. So without a durable power of attorney, your family might be put in a position then of going through the court system to have someone appointed as what's called a guardian and conservator. A guardian is one who cares for your person. A conservator is someone who's going to handle your assets, your business affairs, your finances on your behalf. It's not an enormous, tedious process, but it can take a couple months and it can take a couple $1,000s, depending on how you put it together. But with a little bit of estate planning, this could have been avoided. If you had a durable power of attorney, you would have, during your life, named someone who could act on your behalf in the event that's needed. It's just one document. Name someone you trust. It doesn't have to be approved by the court. It doesn't need to be filed anywhere. And it will allow someone to take care of these affairs on your behalf, to sign in your name, to handle accounts, to pay utilities, to handle medical, to deal with medical folks. It's an easy piece of work to put together. If you're going to do no other estate planning, at least take care of that for your family. So again, if you die without an estate plan, kind of two things. If you die without an estate plan, your estate is very likely going to be divided to who the state says it should go, and it's going to have to go through probate for sure, unless it's less than $40,000, which is pretty rare. And if you reach a point in your life where you don't have capacity, you don't have an estate plan, you've really put your family behind the 8 ball a little bit. It's a really easy piece. Durable power of attorney is an easy thing to take care of. I hope you don't make that choice, and I hope I've clarified some things for you. Again, I'm Dan Covington. You can always reach me at estateplankansas.com. Thank you.